So now we'll continue with the topic of Metaverse, one of the digital applications, let's say, of the design law and the challenges and opportunities that it presents. I think you might have heard already of the Metaverse because it's such a buzzword since 2020, 2021, but actually the first time this word was invented, this term was used, it was by an author called Neil Stephenson, who wrote a novel in 1992, so more than 30 years ago, where he described how the world could be where people would interact between each other as avatars in virtual reality. And actually, if you read the description of this novel, it's quite scary because we may actually come down to the world that he described in his novel, and so for him it was this possibility of virtual interactions in the universe, and he described Metaverse as the next step of the development of the internet, which back then was just appearing, let's say. And then it became a buzzword actually when Mark Zuckerberg changed the name of his company, of the mother company of Facebook and Instagram to Meta, and started promoting this idea that everything will become the Metaverse. There is no definition yet of what Metaverse is, let's say, in the law, but for instance, there was a very interesting webinar that I'm linking in the presentation that you can later visualize, the webinar by UIPO on how they're facing challenges with Metaverse in trademark and design examination and what they're planning to do with that. And there they have defined that Metaverse is an immersive and constant virtual 3D world where people may interact through an avatar. And there has also been some case law in the US where the judges are trying to define what Metaverse is. An example would be this virtual world created, I think, 2 years ago by the European Commission, by a project funded by the European Commission. So they designed this kind of beach party where you could attend, and there were DJs, and you could browse through this world and participate in this rave parties. But unfortunately, very few people signed up. So there was a buzz in the news, and it's actually from a news article saying that, well, later there were only 30 participants, I think, for this whole Metaverse designed by this project. But actually, for those of us who are playing video games or other kind of games in virtual and augmented reality, Metaverse is something we can easily understand because it's just the next step after the video games, where you can create your own avatar, you can buy weapons if it's more kind of war games, or buy clothing. And here I'm giving an example of a game which is apparently the most popular game in the world, which was done by Kim Kardashian and her team. And in this game, she launched a collection of clothing that you could buy for the personage, for this avatar that you were playing with. And this collection reflected a real life collection by Balmain, so the designer, who's very actively cooperating with Kim Kardashian, and you could actually buy for your avatars the clothing that you could find that year in the fashion line. And this is where we see all these design issues appearing. Well, of course, here it was a partnership, but maybe if a game that is not affiliated with Balmain starts selling clothing which is a lookalike of a real life Balmain fashion line, is there an infringement? We have to register the designs, etc. So that's what we will be discussing today. But as you see, the Metaverse is just a step further after this virtual reality games. And the main trait that is missing now from creating the Metaverse is that they have to be, this Metaverse has to be a single one, and all kind of different companies have to interoperate between each other. So say if you start a game which is launched by Microsoft, and you have your avatar. The idea of the metaverse is that you should be able to switch with this avatar and the clothing or the weapons or whatever that you bought for your character. You should be able to switch to a game which is launched, for instance, by Apple. So it has to be cross-functional. And the problem is that companies, they try to advance in their own virtual realities, but they don't want to cooperate in between each other and make these universes interoperable in between themselves. So in the end, it's just another virtual game for now. And also my personal opinion is that after the COVID pandemic has finished and there is no lockdowns and we're not closed down at home, I think people are trying to have more real experiences, physical emotions. So there's no need so much for a virtual reality where you can go to a party if you can go to a real party instead. So what journalists are saying is that Mark Zuckerberg is actually investing less money now in the metaverse, and there's less research. But maybe it can change, because those of you who have been working with artificial intelligence, you might remember that there was also a big hype on whether AI products are copyrightable or patentable, and for some years, there was no real application of these discussions, but now with the ChatGPT, there is a new search and we need new legislative solutions. So maybe metaverse and the problem it brings for IP law and for design law in particular will come back in the near future. So we will take a look into how metaverse and design law interact in between each other on the example of the European Union. And what are the answers that the European Union is currently suggesting for this kind of digital designs, including those that are used in the metaverse. So just to remember, let's say, the key concepts of EU design law, because they are, of course, applicable in the metaverse as well. Under the EU design law, under the regulation of 2002, design is the appearance of the whole or part of the product. And the product, of course, was when this regulation was written, because it was written in the late 80s of last century. The idea was more of the physical product. So you have a Tiffany bottle or a Mercedes, and that's the classical, let's say, application of the design law in the markets. By the way, I had to use the artificial intelligence tools of the IPO to do this slide, because I first included the designs that I found in the database. I completely forgot to include the references, and then I had to do the image search that we've heard during the first and second presentation to find my original designs. But the time evolving with new digital objects appearing, the IPO, but also national offices, they have more and more of what can be called digital designs. And one of the first movers there were the so-called graphic user interfaces. So what we see on the screen of our phone, for instance, or of our laptop. And already there, the discussion started whether these objects that would only exist in virtual reality, whether they can count as physical products as per the definition of the regulation 2002. In the EU, those of you who are cooperating with the IPO, you surely know that there are the registered designs, but there are also the unregistered designs. So once you make it public, once you present it at a fashion fashion fair or art fair, or once you publish a catalog of your furniture, even if you don't register this design, it can be protected during 3 years as an unregistered design. And we will see why this is important for the metaverse. And unlike what was presented to us by the colleague from Thailand, in the EU, you have the requirement of novelty and individual character, which can be also understood as originality, the requirements of protection. Currently, the European Union is planning to revise the legislation on EU designs. And there is already a text of the proposal, which you can open following the presentation, in the link in the presentation. It was published by the European Commission exactly 1 year ago. and it's currently in the European Parliament to introduce amendments by the European Parliament and then to be voted and applied. Actually, when the European Union was thinking of this reform, they did several studies, impact assessments, and the legislators saw that the system is functioning quite well. There are only few issues, let's say, that have to be resolved. So it's a very, let's say, limited vision of the EU design regulation. And mostly the changes were motivated by this digital world, because as I said, the text of the legislation was written more than 30 years ago, and back then the drafters of the regulation, they couldn't think of Metaverse or 3D printing. Actually, you can see that this new text, this new EU design regulation, it reflects a lot the advancements in 3D printing and video games. So it answers to these issues. And there are other provisions that are not relevant for the Metaverse, but I'm mentioning them on the slide just in case you're interested in the reform. So one of the drivers of this reform is the 3D printing. It is actually mentioned in the recitals of the draft text of the regulation as a possible model, threat for the right holders, because you know that with a 3D printer you can scan an object and then print a replica, let's say, of this object, and the object might actually be protected by design law or by trademark patents. So a lot of IP rights may be involved in this 3D printing. And the previous legislation, well, the current legislation, let's say, the design legislation in the EU, didn't have specific provisions that could help us address the challenges of the 3D printing. So, for instance, for those of you who are less familiar with how this works, you have online sites, online platforms where you can download digital files that are called CAD files, and then you use it with your 3D printer at home, or you know, you have a small business. And using these files, you can print, for instance, a copy of a Lego figurine, and this would actually possibly infringe the design rights that Lego has in this figurine. And actually, files related to Lego, let's say, are the most popular on these platforms, and that's why the European Union, in this suggested revision of EU design law, they include a new exclusive right for right holders. So now right holders, they would have the right to prohibit the creation of a file. So let's say what the result of scanning a Lego figurine and doing the CAD file, the creation of the file, its sharing on platforms. So they would be also able to sue, for instance, this platform that offers you the possibility to download the files, and yes, the creation, the storage, and the printing of the figurine, though they could go after the 3D designer, after the platform, or even after the end user, if the result of the printing from this file would be infringing on an existing EU design. So how is this reform answering to issues related to Metaverse? First, the European Union is suggesting to change the definition of what a design and product is. As I said, it was written a long time ago, so the product under the current legislation is defined as something that is an industrial or handicraft item, and was already hard to register, let's say, if we read it literally, hard to register digital designs, but the IPO, they have been flexible in this regard, and their practice accommodates also digital designs. You can check the UIPO guidelines to see that they accept graphic user interfaces and icons, etc. So the objects that only exist in digital world, they do accept them under the current legislation, and you may find this kind of designs registered in the EU. So this is like several screenshots of a video game. But to make it more consistent, now the draft regulation suggests to amend the definitions and to also include products that only exist in a digital form. So specifically, now you will have the graphic user interfaces and logos and other digital objects that will be explicitly recognized under the legislation and not only on the level of the EIPO guidelines. So this will make it easier for the users for the right holders to register their designs. Then you have the issue of product indication. So you know that when you apply for design, you have to indicate what kind of product, where will it be applicable, let's say. This requirement stays the same in the draft regulation. So far, the IPO has issued some guidance as to how to apply for digital objects that will be used in the digital designs that will be used in the Metaverse, and they suggest different, according to situations, different product indications. So, for instance, if it's only intended for the virtual use, if it's only a fashion line that will appear in Kim Kardashian's video game, they still suggest to indicate both physical and virtual product indications, so the dress and the virtual dress, for instance. The thing is that under the EU law and under the EU case law, the case law of the Court of Justice, even if you limit the product indication, even if you only say that it's applied for furniture, if later someone starts doing, let's say, cakes, for kids' parties in the form of your super specific furniture, it still will be considered an infringement because the rights of the right holders, they're not limited to what he has indicated, the product indication. So if we apply this reasoning to the Metaverse, even if you don't specifically mention that it's a virtual dress or a virtual helmet for a war game, and you only apply for it in the physical world, it will be protected also online. So there is no specific issue for the applicants in that. With regard to representation of the design, because the current legislation only speaks of physical objects, as a result, the legislation, the bylaws also only allowed statical views, let's say, of the design. So you can, when you apply for design with the IPO, you can submit up to 7 different views as photos, let's say, or drawings of your design. And the IPO allows, as an addition to the 7 static views, to upload computer animated design, but they do not replace the 7 views. So as we've seen, for instance, during in this video game, you choose 7 specific views of how this game will be, but you cannot upload a whole file. And the same here. So it's also a video game for a phone, and the applicant chose different moments of this chef doing sushi, but he cannot upload a file, a digital file as itself, only the digital file for protection. This will change if the new legislation is adopted, and now movement, transitions, and any other sort of animation would be allowed for the representation of the design. So this means that in the future, the IPO will accept video files and 3D digital representations only. So not only the pictures, but also moving files. There is an issue very specific to the European Union, but you might relate from the perspective of your national offices. The issue is that we've mentioned that, for instance, if an unregistered design is published in a catalog at an art fair or just presented in an art fair, it's called, within EU design law, this is called making available to the public, making a design available to the public. And the design starts to be protected from this moment of time of when it's made available to the public. So in the Metaverse related circles, the question is whether showing, a new piece of clothing in the metaverse or in the video game amounts to this making available to the public, and whether the platform where this game or this metaverse, where does it have to be hosted, whether it has to be open to EU users, etc. And one of the let's say issues behind this is that in the European Union currently there is a norm that says that a design has to be made public within the territory of the European community to be protected as an unregistered design. It was part of the EU enlargement reform, in 2004, where, let's say, questionable wording was included in the design regulation. And as a result, there are discrepancies between EU member states as to whether, for instance, you can in the physical world present something at the New York Fashion Week, whether it will give rise to the protection of the unregistered designs. Certain member states say it does, other member states say it doesn't. And if it's applicable to the metaverse, let's say, environment, we may ask each others whether the metaverse platform, so the world created, whether it has to have a seat in the European Union, whether it has just to reach EU circles, whether it has to be open to the public, or whether it can be a closed environment only for a certain specific time of gamers. The EIPO hasn't had to deal with this yet with regard to metaverse. But there have been some cases with the 3D printing and with other uses in the internet that offers us some answers. And the IPO said that making available in the internet is sufficient, provided it reaches the relevant circles. Let's say that the platform can be hosted anywhere. And also in a different case, the IPO said that it doesn't matter whether it's a platform that is only accessible through a password or through a paid access. It doesn't matter. The important is that this fact of making available to the public reaches the relevant specialized circles. So they are aware of this presentation, they are aware of this game, they're able to reach it. And then if address is shown in this kind of closed universe online, it will give rise to the protection as an unregistered design. And the last, not an issue, let's say, but more a thing to bear in mind if you want to protect your digital objects from the metaverse in the European Union, is that in the European Union, you have this theory of full cumulation of rights between designs and copyright. So you can show your nice dress in your metaverse environment, and register it as a design with the IPO, but it can also be protected as a copyright work, provided it's sufficiently original. It's not, so for the time being in the current EU design regulation, it's not written as such in the law, let's say, but it has to be, it has been the result of the practice of the Court of Justice of the European Union that has been interpreting the law in the past 30 years, and it has said that yes, there is no impediments for an object if it's original enough to be also protected to the copyright work. So for a right holder, for a designer in the metaverse, it means that maybe you don't have to register everything, because some of the objects, some of the digital objects that you will present in your metaverse environment, they will be actually protected automatically for the life of the designer and 70 years after that. But of course, you can also choose both ways. You can register it as a design right and have the copyright for it. There hasn't been any case law so far for the metaverse, but the EU Court of Justice has recognized, for instance, that the graphic user interfaces, so the screens of our phones, can be protected by copyright. Elements of video games can also be protected by copyright. And so you have this double protection available to you in the metaverse. So for me, in this area, the key takeaway is that technology always develops faster. It's completely normal, because sometimes we hear that the law, the IP law, is not prepared for the metaverse. I don't think it's actually true, because thanks to these video games, the 3D printing, which have a lot of similar features with the metaverse from the perspective of IP law. Actually, the practice is there, the norms are being prepared, and the EU is completely ready to digital designs that can occur in the metaverse. But of course, there are other questions from the point of view of IP that you can study, you can focus on, such as the copyrights, the trademarks protection, because of course you can also sell this nice Balmain dress with the Balmain name on it, and it can be the case that you have not negotiated the license with the designer. There is the issue of platform liability, because this metaverse, it will exist on some kind of web page, such as the decentralized. So it's so far the only metaverse platform that exists, and we will also have to face issues from the point of view of interoperability and standards between different platforms created by Microsoft and Apple. And it's also an IP question worth looking at. I've left you some materials that you will be later, you can later access through the PowerPoint presentation on how design protection evolved in 3D printing and graphic user interface, and you will see that most of the answers for the metaverse are there. And I also recommend you to finish the day today after the conference. I recommend you this EIPO course from last year on trademarks and designs in the metaverse. Thank you.
Thank you very much for the interesting presentation. I think maybe it's a little bit too new for most of our participants. For me, especially, I'm more familiar with multiverse and Marvel, unfortunately. But anyway, there's one question on the concerning digital designs. So, will the revision of the EU law make it easier to protect digital designs?
Yes, completely. So as we've seen, the IPO is already very open to these digital designs, but it's more on the level of how they've treated this in the practice, how it's evolved in the practice. But now it will be in the law. So, for instance, the IPO will be ready to accept just a 3D file. So just like a video animation, it will be enough to apply for the design. So it will be important in the EU, but also, as some of our listeners know, the EU then negotiates agreements with other countries, with Vietnam, with Singapore, where it tries to promote its vision. So I think after the European Union adopts this reform internally, it will also try to expand these approaches to digital designs worldwide. So it will also affect other countries.